Okay, and my time is showing 1 o'clock, so let's get started. Welcome to Respectful Workplace Week 2025. This is day 2, and before we begin, on behalf of the Respectful Workplace Week team, I would like to acknowledge that today's program is being presented from the unceded homelands of the Wolastoqey, Mi'kmaq, and Pescatawamacati peoples. This region is covered by the Peace and Friendship Treaties of 1725, which did not include the surrender of lands and resources, but instead recognized Wolastoqey, Mi'kmaq, and Pescatawamacati title and established rules for what was meant to be an ongoing relationship between nations. We also recognize that there can be no reconciliation until we all know the reality of the treatment of Indigenous peoples in Canada, including at residential schools and day schools. My name is Michelle Thompson. I'm going to be your host for day 2. For those of you who don't know me, I'm the Executive Director of the Public Legal Education and Information Service of New Brunswick, PLEIS or PLEAS, which is the lead organizer of this year's Respectful Workplace Week programming. Thank you so much for joining us for day 2. If some of you tuned in yesterday, you'll know that we had a great start yesterday with some really interesting speakers about equity and neurodivergence and psychological health and safety, respectful work for artists, and some of the ways that occupational therapists can help in the workplace. And we're following that up today with a shorter half day, but once again with some really fascinating topics and people. I have a few housekeeping items just before we get started. This event is being hosted on Zoom, so just in case you aren't familiar with the platform, because of the size of our audience today, your cameras and microphones have been turned off for this event, so we won't be able to see you or hear you. But if you want to send us a question for our speakers or a comment, please use the Q&A function that you can find at the bottom of your screen. Anything you submit through the Q&A will come to me, and I can either answer your question directly or pass it on to our speakers during the Q&A section of their presentations. You can also use the Q&A function to send us questions about any technical issues you're having or questions about logistics, and someone from our event team will respond to you privately. You don't have to wait until the end of a session to ask your questions. You can submit them as you think of them. We do want to hear from you, so please feel free to use that function. You can also use the reactions button at the bottom of your screen to applaud if you feel so inclined. If you're here now, it means you're registered for the full afternoon, so you can come and go as you please. Thank you to whoever's testing the reactions buttons. You can always rejoin our programming using the same link. So we understand it's a work day. If you need to step away, come on back. You can use the same link to rejoin. We also have simultaneous translation available all afternoon. You can turn it on using the drop-down menu at the bottom of your screen. Thank you so much to our translators for being here and helping us today. It's a very difficult job, but we really, really appreciate their work. Today's sessions will be recorded, so please be aware of that when you're asking questions. We will post the video on the main PLEIS website, which is legalinfonb.ca, sometime in the next couple of weeks. So you will have the opportunity to rewatch everything that happens here today. Finally, at the end of the day, you're going to see a quick survey pop up. Please take this opportunity to give us a little bit of feedback on the program. It should take no more than about 2 minutes to complete, and it does help us a lot. With all of that out of the way, I don't want to eat into our speaker's time too much, so I'm very, very pleased to introduce our first speaker for today, Khurram Khurshid. Khurram works as the Manager of Advocacy at the New Brunswick Human Rights Commission and has been with the Commission in a research role since 2017. He has degrees in English and law and previously worked as an academic teaching English literature at universities in Pakistan, New Brunswick, and the Middle East. Khurram, the Human Rights Commission has been an amazing longtime supporter of Respectful Workplace Week, and I'm so glad to have you here with us today to talk about the new guideline on racial discrimination and its implications for the workplace. So with that, I'm going to hand it over to you.
Thank you, Michelle, and a good day, everyone. And thank you for joining the Human Rights Commission for this session on race rights under human rights law. I first off respectfully acknowledge, just 1 second, please. I just need to minimize something. I respectfully acknowledge that New Brunswick is situated on the unceded and unsurrendered territories of the Wolastoqey, Mi'kmaq, and Westcotomougati peoples. We seek to repair and rebuild meaningful relationships with Indigenous peoples and honor these lands, which hold the hopes of future generations. So I will begin today's talk with a brief outline of the mandate of the Human Rights Commission and the scope of the New Brunswick Human Rights Act, for they are the primary mechanisms for addressing race discrimination in the province. And then I will summarize the meaning of race, racism, and race discrimination under human rights law, and the legal principles that are applied to assess race discrimination complaints when they get to the Human Rights Commission or to the tribunals and courts. So the commission was established in 1967, the second commission to be established in Canada after Ontario. Its main function is to administer and apply the Human Rights Act. It operates at arm's length from government, which essentially means that it is independent in its day-to-day operations. And when addressing human rights complaints that are filed with the Commission acts as an impartial quasi-judicial body. It can summon witnesses, record evidence, visit premises, and so forth to assess filed complaints and submit reports or recommendations to Commission members. Essentially, then, the Commission enforces the Human Rights Act impartially, and it also has carriage of justice when complaints get to the courts to ensure that the Act's protections are applied. Briefly, administratively, the Commission has a twofold structure. There is the Director's Office comprising of civil servants who manage the day-to-day functions of the Commission, and Commission members who are appointed by the LG in council. They are not civil servants. They represent the cultural and geographic diversity of the province. Members oversee recommendations of the Director's Office on human rights complaints. They can reject findings of reports completed by Commission staff, and they can hear appeals on Directors' decisions on complaints. And this structure essentially ensures checks and balances and citizen oversight over the work of civil servants through a members or people's commission and their representatives. The Commission has two main functions. It receives, mediates, and investigates complaints of discrimination. And in that role, it acts as a quasi-judicial body, and also as a gatekeeper to the judicial system by screening out frivolous and non-jurisdictional complaints from getting to the courts and saving courts expense and time. The mediation services offered by the Commission, if parties to a complaint agree to settle their dispute through mediation, are free of charge, they are confidential and without prejudice. And every year through its mediation services, complainants receive hundreds of thousands of dollars in settlement damages and other non-monetary remedies. If complaints are not settled at the Commission, they can be referred to the Labor and Employment Board, which is a judicial tribunal independent of the Commission. And complaints can escalate to the higher courts through the appeals process, right up to the Supreme Court of Canada. And the Commission also has the legal mandate to educate the public about human rights and obligations, to raise public awareness about obligations under the Human Rights Act. And in this role, the Commission makes presentations, publishes informational materials, collaborates with civil society, other rights groups, etc., to disseminate human rights messaging to wider sections of society. So the Human Rights Act, very briefly, it's the principal legal instrument that governs human rights in the province. It creates the Commission and it sets down its mandate. Of course, the jurisdiction of the Act is provincial, that is, it is limited to New Brunswick. It does not operate or apply in other provinces or territories or to the federal jurisdiction or federal entities. One important feature of the Act is its quasi-constitutional status, which has been conferred on it by the Supreme Court, and many human rights acts in other jurisdictions have this provision within the statutes themselves. This is a paramountcy status, so the Act is paramount in the provincial legal sphere, which essentially means that if other provincial laws, agreements, contracts, rules violate its provisions and these issues become the subject of a complaint, the Human Rights Act's provisions will prevail. And this ensures that human rights interests are supreme and other provincial laws or policies do not violate human rights principles and protections enshrined in the Human Rights Act. The Canadian Charter supersedes the Act in the sense that if something in the Act violates Charter rights, then the Charter will override those provisions. And this is consistent with across the jurisdictions for all human rights commissions. All of the acts in other jurisdictions also comply with the Charter, and this ensures a harmonization of human rights protection and frameworks across Canada and all legal jurisdiction. Lastly, one feature that begs mentioning is that the Act is remedial in nature. It's not punitive. It does not send people to prison or give them a criminal record. It is essentially an anti-discrimination law. It does not protect against criminal acts or torts or civil wrongs or contract law and so forth. The intent of the Act is to correct a human rights wrong that has been committed and to restore complainants to the position they were in before the discrimination or violation of their human rights took place. And through this process, complainants can receive general damages for injury to their dignity and self-respect, and damages for substantive monetary loss, for example, loss of pay, and other non-monetary remedies, restoration to a job lost because of discrimination, etc. And it is perhaps the only law that compensates people for loss of injury or dignity or feelings and self-respect. So the Act protects against discrimination, which is the crux of human rights. And it does so based on 16 protected grounds. And these grounds are personal attributes or markers of personal identity. And by the very condition of our humanity, each of us will identify with at least one of these grounds. The Act also protects against sexual harassment and reprisal, which are not personal characteristics, but acts done against the person. When the Act came into effect in 1967, it had 6 protected grounds, including race, the first 6 listed on the left of this slide. And it has evolved over the decades as new rights holders have, uh, you know, have voiced their the recognition of their rights. Different advocate groups, and new rights have been recognized, and that's why it is a very socially conscious regulation or law. It keeps pace with social changes, and as new rights are recognized, they get accommodated within these protections. And already new rights are on the horizon. We have, discussions on genetic discrimination, algorithm discrimination, data rights, and so forth. So this list might increase as in the coming years or decades. Also, the Act protects against discrimination in 5 areas only. So the Act will come into play when someone can show that they identify with one of the 16 protected grounds and they suffered discrimination in one of these 5 areas. And since we are discussing employment rights, I will focus on the scope of employment protections in the Act. So employment covers a wide spectrum. It starts with job ads posted on for employment, application screening. We speak of resume racism, job interviews, and everything within the course of employment, hiring, terminations, promotions, training opportunities. All of these employment decisions during the course of employment fall under the Act's protections. So if there is violation based on someone's race in these decisions and the person suffers adverse impact, that would be protected under the Act. The Act employment protections also protect the terms and conditions of employment, which itself is a very wide arc. It includes the job environment, or the atmosphere, the emotional and psychological environment of a workplace. If, for example, it is toxic or poisoned by derogatory jokes about someone's race, etc., that would fall under the Act's protections. And the other four areas are services, rental housing and sale of property, notices and publications, and professional or business associations. So to talk about race rights and understand race discrimination and its scope within human rights framework, and to frame this discussion, it is useful to very briefly look at the meaning of race itself and how this meaning has been constructed historically and how the idea of distinct races and separate races has come about. The term race, as it is used, it classifies human beings into distinct physical, biological, and genetic groups that are recognizable by their physical features. Under the Act, the definition of race includes people who are African Canadian, Asian, or Caucasian, etc. And within the context of the West, very broadly, or within the context of modern or contemporary Western civilization, the idea of distinct races was systematized from the 16th century onwards. And by the late 19th century, and coinciding with the apex of European colonization, a vast body of race scholarship or theories of race had emerged. And these ideas became entrenched in this collective social consciousness. And gradually, these ideas also permeated or embedded cultural, political, institutional, and legal systems and frameworks. Essentially, the race theories divided humankind into distinct race categories based on skin color, including black, white, yellow, and red, and more permutations. And more importantly, situated these races in a hierarchy with the white or Caucasian race uppermost in this assumed ranking, and thus giving way to simplified stereotypes or binaries like civilized and primitive, superior and inferior, pure and impure races. And correspondingly, and more disparagingly, the personalities, moral behaviors, and intellectual capacities of individuals and groups were also attributed to their racial origin, suggesting that race was an unchanging inner essence, and people were either superior and civilized or inferior and primitive owing to their racial identity or background. And because of the dominance and power of these ideas, the colonial context is important here. These racial categories and hierarchies came to be seen as logical and natural, suggesting that the non-white races were not only inferior, but they were inferior, or their inferiority was naturally determined or created by nature. These theories have now been debunked as pseudoscience, and modern research in genetics and the life sciences has established categorically that human beings share the same biological or genetic makeup, and their differences exist only in outward physical features like skin color or hair type, etc. Race, therefore, is not a biological category or reality. However, the concept of race exists as a powerful social reality. It is still widely accepted, and it permeates social relations and institutions and their systems, practices, and structures, creating a dynamic of power and privilege and impacting people's lives in practical terms. Because judgments and decisions are made based on these stereotypes, consciously or unconsciously, that create adverse impact for racialized groups. It was only after the Second World War, when the UN was set up and the Universal Declaration of Human Rights was written up, and other international instruments, including the International Convention on the Elimination of All Forms of Racial Discrimination, that these theories were dismantled and rejected. Between 1950 and 1967, UNESCO issued 4 statements on the race question, written by expert groups of sociologists, biologists, and physical anthropologists, just debunking the ideas of the intrinsic superiority and exclusivity of certain races. And now, with the establishment of human rights institutions like ours in nation states and provinces within federal states, legal mechanisms are in place to prevent race discrimination. One more attribute that needs to be mentioned is that human rights law recognizes that personal identities are complex and multi-layered, and they are shaped by multiple factors or intersectionality. That people may be disadvantaged by more than one personal trait or characteristic. And the identities of racialized persons are particularly enmeshed and intertwined with other protected ground or other protected characteristics like color, ancestry, national origin, religion, etc. And race discrimination against racialized persons may often be triggered by these other protected grounds. And because of this, race discrimination is sometimes disguised under seemingly less offensive identity markers, like a person's accent, for example, their country of birth, or their religion. And these can become euphemisms or proxies for notions of race in race discriminatory conduct. And this intersectional factor makes racialized persons vulnerable to what's been called racisms or multiple forms of race discrimination. So while race is a marker of identity, racism is an attitude or way of thinking which can manifest in comments, conduct, behaviors, policies, etc., that result in unequal treatment, exclusion, or adverse impact for racialized persons. I just posted these two definitions here. One is by UNESCO, the other by two race scholars. And they just reinforce the idea that racism is associated with or stems from notions of hierarchy, superiority, domination, ideology, exclusion, and power. Racism confers power and privilege to the dominant group, and Peggy McIntosh coined the term white privilege, which refers to unearned advantages that accrue to white persons mainly on account of their race and shape their life experiences, just as race or racism shapes the life experiences of racialized persons in negative ways. Racism is often unconscious, and the Supreme Court has acknowledged it, and other courts and tribunals frequently acknowledge that attribute. Stereotypes about race may be internalized or unconsciously held and play out at a deeper psychological level, so that people sometimes may not even be aware that they hold these beliefs. And this is one of many reasons why racism can be particularly insidious, subtle, and complex, and why it has been so difficult to weed out from the social fabric. Racism can manifest in everyday racisms, which is essentially everyday behaviors or attitudes that crop up in social interactions and are disparaging for racialized persons or condescending to them. They can show up in microaggressions, which are again behaviors that are rooted in racist beliefs. And again occur in day-to-day situations. For example, asking uh, a black person where they are really from, or labeling a black woman as aggressive because of the tone of their voice, or following a black person in a store uh, just because of the suspicion that they will do something incongruous. Racism also encompasses racial gaslighting, which happens when the lived experience and emotions of racialized persons are discredited or not believed or brushed off. And scholars speak of new or cultural racism because the race theories of the past have lost their appeal. We say that racism and race ideas regenerate in disparate ways. So when those pseudoscientific theories of biological superiority do not hold appeal anymore. New forms of racism would emphasize cultural difference or the superiority of Western or European cultures as a mode of differentiating, disparaging, or excluding racialized groups. And because of the complexity of this issue, and because the history of racism is scarred by exploitation, violence, and dispossession, it is a complex problem to address, among other things, due to the trauma and shame associated with its historical memory. Conversations about race can be difficult for many people. They may make people uncomfortable, and many people may even feel that they do not possess the politically correct vocabulary to discuss these issues with knowledge and sensitivity. And due to all these complexities, a human rights based approach is the most viable way to address issues of racism and race discrimination because it is informed by the principles of dignity, equality, inclusion, non discrimination, and accountability. And it is supported by legal frameworks and education and awareness raising about these issues. So, race discrimination, what does it entail? Its basic definition, while uh, race discrimination may often result from racism or racist beliefs, but human rights law does not protect against racism per se or against racist beliefs if racism in the state of mind or states of mind are not really susceptible to uh, investigation. But the Act's protections are activated when these beliefs are manifested in actions that lead to discriminatory or adverse impact in employment, housing or services, etc. Uh, and essentially, race discrimination happens when people are treated differently than others, and this differential treatment either imposes burdens on them or puts them at disadvantages that are not put on others, or the conduct or behavior withholds from these people equal access to opportunities or benefits in employment or other protected areas. So very quickly, just a quick summary of these 3 or 4 forms of common forms of race discrimination. Of course, it can be personal, that is stemming from an individual's attitudes, biases, or behaviors, which may in turn reflect the norms or rules of a society or a culture or a workplace, unwritten or even unspoken, and which create power imbalance for racialized persons. Race discrimination can also be systemic or institutional, as often is, that is, flowing from institutional policies, rules, or practices that are entrenched in the system from long historical legacies and institutional policy making, and which can interweave to create disparities and barriers for racialized persons. And systemic discrimination is harder to dislodge. It can only be fixed by systemic remedies. The Supreme Court has repeatedly emphasized that institutions, governments, and public bodies have the ultimate responsibility to take measures to remove systemic barriers in employment and other areas. Uh, if you can imagine one step deeper than race discrimination, it can also be structural. Structural racism exists through the labyrinth of the state itself, through immigration laws, criminal laws, welfare laws, housing policies, which give effect to racial hierarchy and the exclusion of racialized persons from benefits generally available to other groups. And lastly, race discrimination manifests in racial profiling, which happens when people in positions of authority, like law enforcement, scrutinize racialized persons more severely than others on the pretext of public safety or security. It is different from criminal profiling, which does not rely on stereotypes but on objective evidence to profile criminals. And there's also consumer racial profiling, which is the practice of providing different treatment in services or in a marketplace setting. Typically happens in hotels, restaurants, gas stations, malls, and so forth. can also happen in services, government services, etc. So while racial profiling does occur in services generally, but it can also happen in employment settings and create adverse circumstances for racialized groups. So this is the legal test that's been set down by the Supreme Court of Canada, and it's called the Moores test. And so to show racial discrimination prima facie on the face of it, a complainant must fulfill these three steps. They must show that they identify with the ground of race or another intersecting ground like color, religion, or national origin, and so forth. They must show that they suffered adverse impact in employment, and the adverse impact should be palpable, like they lost a job, they were not promoted, they were not hired, or they suffered other disadvantage compared to others, and that race was a factor in the adverse impact. This nexus is important to establish. If a complainant can establish these three facts, the commission will accept the complaint and investigate it, and then the onus will shift on the respondent to prove, to show that either they did not discriminate against the person or that discrimination was justified. That is, it was either a bona fide, in good faith occupational job related requirement, or the respondent had reached the point of undue hardship, which is reached when accommodating a person is too difficult due to monetary reasons or health and safety reasons or other legitimate work related reasons. And all these factors need to be, again, proved with tangible, substantive evidence. So based on human rights jurisprudence, decisions of courts, including the Supreme Court of Canada, these principles have been established, and these are used by courts to assess discrimination, race discrimination complaints. So first of all, it is not a defense to say that they did not intend to discriminate against a racialized person. Intention is not material in discrimination analysis. The law will look at the effects of discrimination on an aggrieved person. It disregards the professed intentions of parties. So parties will be liable for discriminatory behavior of actions, even with the best of intentions, if the effect is adverse impact due to a person's race. Secondly, it is enough to constitute race discrimination in a court of law if race was one of the factors in the alleged discriminatory actions. It does not have to be the only factor or the main motivation, the most significant or material factor in the discrimination. As long as it was one factor in the discriminatory conduct, it will pass muster in a race discrimination analysis. It is not a defense that a racialized person was not discriminated because other members of the same race did not face discrimination in the given employment setting, and employs two indigenous persons, for example. One of them suffers discrimination, the other does not. It is not a defense that because the other person was not discriminated, there was no discrimination against the complainant. Furthermore, and this is an important aspect, like other forms of discrimination, race discrimination is also often proved by circumstantial evidence and by inference rather than by direct evidence. These are less stringent evidentiary rules that are applied by courts just to ensure that the protections granted in human rights statutes are applied with a liberal, contextual, and purposive interpretation, in keeping with the objective of human rights laws to protect human dignity and to ensure the social inclusion and equality of all persons. And also, lastly, as mentioned earlier, courts also recognize that race discrimination and stereotyping may often result from unconscious or internalized biases and prejudices that people have about racialized persons. Similarly, again, case law has established if a person is treated acceptably in the past but faces discrimination later or in the future in their employment setting, it is not a defense that because they were treated acceptably earlier, they were not discriminated against later. Uh, Again, it is not a defense uh, that a racialized person was not discriminated against because the respondent themselves are uh, racialized or also identify with the ground of race. Intra-race discrimination, uh, that is discrimination, race discrimination by people who belong to the same race, is also recognized as discriminatory under the Act. It is also discriminatory if someone discriminates against a person based on a perception that they are racialized. In such situations, even if a complainant does not identify with the ground of race, but they are treated unfairly because of a perception that about their race, the treatment would be prima facie discriminatory under the ground of race. And likewise, discrimination against a person due to their association with a racialized person. If an employee is married, is not racialized themselves, they're married to a racialized person, and they are discriminated against based on that association. That is also recognized as discriminatory under human rights law. Again, based on human rights case law, the following actions in the course of employment would be seen as red flags or indicative of prima facie race discriminatory practices in employment settings. Generally, differential management practices, such as excessive monitoring of racialized persons or deviating from written policies or standards in dealing with such persons, would be a red flag. Withholding racialized persons or employees from training, mentoring, or promotion opportunities, which are generally available to other workers in their position, would be a factor in discriminatory assessment. Imposing different job standards or expectations on racialized employees, similarly, is discriminatory. Attributing disproportionate blame for work-related incidents to racialized persons. If that happens and that is part of the facts of a case, that would lean a complaint towards a finding of discrimination. Assigning racialized persons to less lucrative or desirable positions or job roles. Many cases where racialized persons are assigned job roles that no one else really wants to do. And so that if this becomes a subject of a complaint, that would be evidence of discrimination. Treating differences of opinion voiced by racialized persons as confrontational or insubordination. And this is generally based on stereotypes that racialized persons are aggressive, loud, or quarrelsome. Penalizing a racialized person for not getting along with a coworker instead of addressing racially discriminatory attitudes, behaviors, or environment in a workplace. This again is based on a stereotype that racialized persons do not either espouse Canadian values, are not Canadian enough, or are not immersed in Canadian culture or the dominant culture of a workplace. And also to this list can be added adverse treatment of racialized employees if they file a complaint against an employer and then they are perceived or labeled as troublemakers. And this is protected under the Act, under the ground of reprisal. Three more situations that are worth noting, again, in the same assessment of a racial discriminatory conduct or behavior. Racially poisoned work environments. So if an environment is rife with racially inflected jokes, innuendos, banters, or teasing someone about their race or their background, that would create a poisoned work environment, or a racially poisoned work environment in this case. And the courts have said that the emotional and psychological atmosphere of a workplace is part of the terms and conditions of employment. In poisoned work environment situations, courts look at patterns of behavior to assess the cumulative or escalating effects of such conduct on the complainant. And in this situation, if employers do not act with due diligence to address race discriminatory conduct in their organizations or environments, they are vicariously liable for race discrimination conduct of their employees, agents, or patrons. It is not a defense that an employer did not know about the race discriminatory conduct or was unaware that the workplace environment was toxic with racist comments or behaviors. Sometimes a single comment that demeans a person based on their race could be construed as discriminatory, especially if it is egregious in nature. Such complaints are closely assessed within the context of each particular situation and the entirety of the facts and circumstances under which an incident unfolded. And lastly, employers are also liable for race discrimination if they fail to protect their employees from racial harassment or race discrimination by their agents or patrons, or fail to address these issues in reasonable and timely manner. A typical example is a restaurant setting or a retail setting where a patron racially harasses an employee, and the employer, instead of addressing that situation, reprimands the employee rather than uh, addressing the situation in more uh, reasonable ways. This is a test which was set up in one of the cases. So if a racialized person is not hired to a position and alleges race discrimination in the hiring process, courts will typically look at the entirety of the circumstances involving the hiring decision to determine if race discrimination was a factor in the decision. And this test is a test of prima facie discrimination, one that the complainant was qualified for the particular employment, that obviously he was not hired or she was not hired, and someone no better qualified was subsequently hired to that same position. If these three elements are shown by the complainant, the onus will again shift to the respondent to show that race discrimination was not a factor in the hiring decision. Either the complainant did not meet the required job qualification, someone else was more qualified, or there was a bona fide occupational requirement of the job that the complainant did not meet, like language requirement or certification requirement. So before moving to the next section, it's worth emphasizing that it is the legal duty of organizations or employers to develop anti-racism policies and to educate their employees and agents about race discrimination. They must implement impartial, transparent, and safe mechanisms to prevent, report, and address incidents of race discrimination, harassment, stereotyping, or toxic environments. If organizations fail to investigate race discrimination complaints or respond to them in an effective, reasonable, and timely manner, they will be liable for discrimination under human rights law. As one tribunal noted, employers must show three things. One, they did not consent to or condone the act of race discriminatory conduct. They did their due diligence to prevent those acts. And three, they acted in a timely manner to mitigate and remove the effects of the discriminatory conduct or behavior. So this is an important principle of human rights and a standard established by the Supreme Court early in human rights jurisprudence in 1982. It has become a cornerstone of human rights law. If a protected person, racialized person, makes a reasonable request for accommodation that is related to their protected ground, the employer's duty to accommodate that request is triggered. Employers must accept accommodation requests in good faith and explore all options to accommodate a reasonable request, including considering alternative measures, next best solutions, and so forth. They may need to make changes or adjustment to their rules or policies, practices, or they may need to adapt physical spaces to accommodate a request. Accommodation is a collaborative process, so employees must cooperate in the accommodation process, must accept reasonable accommodation. They're not entitled to the perfect accommodation. And employers have a right to ask for documentation to support a request. This is typically for disability accommodation request when a doctor's note is required. And employers can refuse an accommodation request if they have reached the point of undue hardship. Again, a Supreme Court of Canada's term, uh, which is that either it was too expensive to accommodate that person. There were health and safety reasons for not accommodating the person, or there were other serious major disruptions in the workplace would be caused if this accommodation request was granted. Undue hardship is assessed objectively and based on facts and evidence. It cannot be used automatically by employers to refuse an accommodation request. Inconveniences or personal preferences are not undue hardship. And lastly, employers may also refuse an accommodation request or treat someone differently because of a BFR or a bona fide occupational requirement. Uh, in good faith work-related requirement or rule, and this is also based on the Supreme Court test called the Miriam test. So, if there is a rule that is related to the work, it is rationally connected to the job that is to be performed. It was put in place in good faith, and it is reasonably necessary for the stated purpose, then it could qualify as a BFR. BFR is hard to prove in race discrimination complaints unless a differential rule is again based on something like a language requirement. If the job requires French language requirement, a racialized person does not have proficiency, then that would be a BFR. And similarly, professional certification requirements in employment would fall under BFR. Generally, to accommodate if employers adhere to the three kind of foundational pillars of accommodation: dignity, inclusion, and personalization. Uh, they would stand in good stead if their accommodation scenario is assessed in courts, if they have made sure that the dignity of the person has been upheld, the policy has been inclusive, and each accommodation has been treated uniquely, personalized way instead of applying it in blanket fashion without considering the uniqueness of each request or situation. Since we have a few minutes, I can just share a few cases that illustrate these race discrimination principles just recounted. So a recent case from BC, African Canadian correctional officer alleged race discrimination against the Ministry of Justice. During the course of the employment, he was called the N-word, termed as lazy, threatened with violence, held to higher standards. Racial slurs, jokes, and innuendos were rife in the environment. He was labeled as a rat and troublemaker when he complained against the misconduct, and eventually had to leave because of mental and physical health reasons. The ministry response was technical, that it is complaint was filed late. Some of the complainants' allegations were eliminated because of the time issue, but their second argument was not agreed to by the courts. There was a nexus between the conduct and the person's race. Uh, and the court stated a very powerful judgment that the employer used myths and stereotypes about race in dealing with the complainant. Uh, and their comments and conduct struck at the core of the complainant's identity and feelings of self-worth and emotional well-being. The court noted that words have a powerful resonance in such situations, And the conduct encompasses virtually the entire spectrum of racial discrimination and harassment in the workplace, and it created a racially poisoned work environment. The case is famous for the highest damages award in BC litigation history. Almost $1 million were awarded to the complainant for lost wages, past and future earnings, pension and compensation, and damages to injury, and so forth. So this is a case where a person was discriminated against due to association with a racialized person. The complainant himself was a Caucasian male. He worked as a mechanic, but he was married to an African Nova Scotian who also had band status. And he was also friends with two racialized colleagues. So he was constantly harassed and discriminated. His tools were vandalized. He was physically assaulted. Racial graffiti was painted in the workplace washroom. And there was the environment was rife with jokes, comments, and insinuations about race. And the complainant had to develop serious health issues. There was a suicide attempt, PTSD, and long term disability leave. Uh, so again, the court held that the complainant was discriminated based on his association with racialized persons and subjected to a racially poisoned environment. The municipality was held vicariously liable for the conduct of its employees for not taking measures to prevent racial harassment and poisoned work environment. And again, this is a case, highest damages award in Nova Scotia. Almost $600,000 were awarded to the complainant accumulatively, both general and special damages. This is a case where uh, a person was discriminated in the course of their employment. They were not promoted. Very highly qualified black vice principal uh, who applied for the promotion to principalship for many years. Many of his colleagues, Caucasians, were less qualified, obtained timely promotions, but he wasn't promoted. Uh, he was given less time off from teaching to perform administrative duties. He was refused approval for the principal's course on grounds that quote only those with an expectation to succeed were being approved. He was challenged about his ability to be the principal of a white school. And during the interview, a member of the school board turned his back to him for the length of the interview. A board of inquiry held that he was discriminated against based on his race. There were systemic race discriminatory practices at the school board, including arbitrary promotion decisions, uh, no policies on promotion, rotation, or release time. Uh, and management made many references to the race of the complainant. This was settled outside of the board, so the damages amount is not known. Last case is relates to discrimination by patrons and agents. So this is the case of a retail manager who's one of the patrons, racially harassed her, and she reacted to the treatment. And the employer, instead of uh, addressing the issue properly, reprimanded the employee and disciplined them. And the court held that uh, the employer acted in breach of the Human Rights Act, and they were expected to put in place procedures to address racial harassment of their staff by patrons to address this situation. Again, the employee was awarded damages for lost wages and injury to dignity, feelings, and self respect. So, most of this is summarized from the Commission's guideline on race discrimination. If you want references to case law or other scholarly academic resources used in this talk, you can consult our guideline and other resources and so forth. And in the interest of time, and also because my voice seems to be kind of thinning out, I will pause here and take any questions or comments.
Thank you so much, Karim. That was really, really interesting. We do have some questions in the chat that I want to make sure we get to. You know, one of the things that really jumped out as you were talking is we cover a lot of content for Respectful Workplace Week related to sort of core occupational health and safety issues, right? Um, And in some ways, the framework you're describing about employer responsibility, about impact, not intent, all of that sits in some ways like quite neatly alongside the way we think about employers as obligations to protect employees from other kinds of harm, right? Like
Right.
we don't care that it was an accident that a bunch of nails got spilled on the floor. We can't have nails on the floor in a workplace. Um, so this was fascinating. I also really appreciate the very quick primer on race theory and the evolution of human rights law. I know how difficult that is to condense, so thank you.
Welcome.
So we had one person in here asking, and I was wondering about this too. Besides disability accommodations, are there any examples you can offer of accommodations on other grounds, or particularly that might be relevant for the race context? I mean, I was thinking about maybe flexibility around time off for high holy days for different faiths. Is there anything else that comes to mind?
Yeah, that would be the typical example because a racialized person may also identify with the ground of creed or religion, and they might need time off for prayer or visiting their synagogue or their church or their mosque, and that would be one typical example of accommodating that person. Because as I said, it's always intersectional, and I could have shared data with you. Last year we received 33 race-based complaints, and all of them were intersectional. And previous years, I mean, more than 95% of race discrimination complaints are intersectional. That is, they are citing national origin, ancestry, color, and religion. These are the common ground that are cited. So if the nexus, if the accommodation request is related to one of those allied grounds and the person also identifies with race, then that would be construed as a kind of accommodation based on race slash the other ground.
Okay. You actually accidentally answered another question here. Someone was wondering how many racial discrimination complaints you guys would get in a year, and if there's anywhere you publish statistics about this kind of thing that they could follow.
Yeah, so in our annual report, we publish all these stats in our annual report. The 2023-24 report is on our website. The current report will come out in a couple of months. So all the data is there. And off the top of my head, 33 complaints that cited race as a ground last year, and I think 30 of them were intersectional. The previous year, 27 complaints cited race discrimination, and all of them were intersectional. So it's a preponderance of data, and that is consistent across other jurisdictions.
Fascinating. We had one other question in here from someone who notes they have noticed that racism is happening in their workplace. It doesn't usually affect them personally. They're noticing it mostly against Black coworkers. They're wondering if there's anything that the commission can offer them in terms of supporting their coworkers, or what you would recommend.
So I do recall case law if someone who is themselves not being discriminated against, but they are impacted by discrimination happening to against others, that would be a poisoned work environment, and they themselves could be, potentially eligible to file a complaint. But then in such situations, because each situation is so specific and fact driven, I think the best recourse is to call the commission. So we have very experienced intake officers who deal with these situations, so they can hear the entire story, the context, and they can advise on next steps. If obviously the employer if is not addressing these issues, then that is a red flag, and the employer should uh, be taking very proactive measures and doing due diligence to address these issues.
Thank you. And if we have 60 seconds left, we had someone who was asking if there are any patterns that the commission has noticed in terms of particular sectors of concern for race discrimination, whether that's like in employment or housing or education.
Right. So I think it's across the board. I mean, obviously we've had complaints about, schoolyards, a lot of that happening with kids and schools. Housing is a very common area because especially newcomers, racialized newcomers have, issues around that. And employment remains the highest number of cases are filed on the basis of employment. So it would remain, the pattern would be more employment and services and then housing. These are the three kind of top uh, areas in which complaints are filed. Um, and generally, the it's uh, it's it's quite noticeable that there's lack of awareness about race rights and about respect and dignity for race, and especially through microaggressions and everyday racism. Those are pretty rife, and those are because those are difficult to address and they are fleeting situations, and so people get away with those, and but they impact racialized person quite deeply, and that's one of the judgments the court said that because racialized person can feel those hurts very deeply because it's almost like they are being kind of you know sort of it hits their national identity or their sense of family and cultural background is being kind of disparaged when they are treated personally like that. So it's I think just more education measures are required generally and for every situation, employment, housing, services, and that's why it's so critical that we disseminate widely this message.
Absolutely. And the Human Rights, if anyone in this call hasn't looked at the Human Rights Commission's education and resources, they are excellent. They have guidelines on a whole bunch of different areas of discrimination. Racial discrimination is new. Racial discrimination is new. The guideline was published this year, but there's really useful tools for education, for starting hard conversations at work or in whatever space you are navigating. So please do check those out and spend some time with those. Thank you so much, Karim. This was absolutely great. We really appreciate you taking us through all of this. If anyone wants to reach out to Karim or get more information about the Human Rights Commission, all that information is easy to find on their website. You're also welcome to email Plius, and we can put you in touch with whoever you need to be in touch with.
And you can email the commission or just call them. So they're very. It's an open door policy. We receive all calls, address all questions that come our way. Every year we address more than 3,000 queries. So it's part of our day-to-day functions.
Perfect. All right. Thank you so much, Karim. And with
Thank
that,
you.
I am going to transition us to our next and final speaker for the day. You may have noticed a theme with the programming for today. Of course, Plius is a public legal education organization. I'm a public legal educator. There's no way we were going to have a respectful workplace week where we didn't try to talk to you a bunch about the law in this area, how the law is emerging, how you may be seeing it come up in the news or in things you're hearing or changes in your own workplace. And so for our concluding session for this year's forum, we are going to have the wonderful Kelly Van Buskirk giving us an update on respectful work and the law, emerging issues and major cases over the last year. Kelly is, of course, the founder and principal of Van Buskirk Law in St. John. After spending about 31 years dedicated to labor, employment, and human rights law, he launched his own firm in August of 2024, which currently has 8 members, which is growing. That's very fast growth. With a background in litigation, university teaching, research, and arbitration, and with advanced degrees, including an LLM from the University of Huddersfield and a PhD from Nottingham Trent University, his adult life has been consumed by the mysteries of workplace law. Kelly, welcome back to Respectful Workplace Week. Thank you for being here again.
Oh, no, thank you. Thanks a lot, Michelle, for inviting me to participate. And if I could, I'd just like to congratulate you and all of the participants in the program for your dedication to the subject, because we all know that this is an important subject for the health and safety of not only employees, but really the larger population. So I'm really thankful to be part of it. Thanks.
Of course.
All right. Now, what I might do, everyone, is just share my screen here, if that's all right, because I'd like to talk to you a little bit about 4 cases that have arisen recently and that might be useful for all of us to think about in the context of the law and conduct in workplaces. Listening to Khurram, I'll make a sort of a comment with respect to his very useful content. He referenced the Francis case and the AZ case, first the Francis case from BC, and second the AZ case from Nova Scotia, both of which are racial discrimination human rights cases. And he made note of the compensation awarded. What all of you may know is that here in New Brunswick, there used to be a real limitation on damages in human rights cases. However, as of this year, we have the Blaney decision from the Labor and Employment Board, which actually exceeds both the Francis case and the AZ case in compensation, and includes a $230,000 general damages award for violation of human rights. That was a case involving political discrimination. And as a result, I think what we can all know here in New Brunswick is that we have to be cautious about our understanding with regard to how human rights violations will be addressed. I think the days are gone here in New Brunswick where employers could treat human rights violations as a sort of cost of doing business. With the Blaney decision, there is a clear line in the sand, and it tells us that human rights violations will likely be treated very seriously going forward. So that was good information from Khurram. Now here, I thought I'd start our discussion with this case of Metrolinx, which you may or may not be familiar with, but if you aren't, I'll give you a quick synopsis of it. It's a case involving 5 employees from Metrolinx, the Toronto GO Transit Commission, basically, or an operator under that service. Basically, 5 employees were found to have made derogatory and sexist and discriminatory comments about a coworker. And they were making these comments on WhatsApp, which is a group chat forum. And they were making their comments outside of work time. The comments themselves were very slanderous in the sense that they alleged that this female coworker had performed sexual favors with members of management in order to obtain career advancement or job promotions. The employee who was the victim of these comments was able to obtain screenshots of the comments themselves and reported those to a supervisor. The victim, though, didn't want to make a complaint. All of you know that that's a reality for many victims of harassment, sexual harassment, and violence. There's a real concern about retribution. There's a concern about ostracization. And so the victim did not want to complain. Metrolinx, though, did an investigation under its occupational health and safety promoted policy, which is, it falls under the Ontario legislation, and the Ontario legislation, its occupational health and safety legislation, is similar to our New Brunswick legislation in terms of requirements for a policy and investigation structures. So as a consequence of the investigation, Metrolinx fired these 5 employees. The employees grieved the dismissals. and the cases went to arbitration. A single arbitrator concluded that any investigation into the WhatsApp comments should have ended when the victim declined to file a complaint. And so this raises a really common question, and it's a question that many, many employers face. The question is, if a victim or an alleged victim of harassment doesn't make a complaint, can we, the employer, assume that nothing further has to be done? The answer, as it turns out in Metrolinx, is no, just to spoil the punchline for you. But I think that's a really important thing. Sometimes because employers are approached by employees who say things like this: listen, supervisor, I need to tell you something, but I don't want you to do anything about it, and I don't want you to tell anyone. And then they proceed to talk about, being allegedly harassed or sexually harassed, and they have now sworn their supervisor to secrecy. So a tip that comes from the Metrolinx case is that if you find yourself in that predicament, the best thing to do is not promise secrecy. Do not confirm to the employee who is telling you this information that nothing will be done about it, because your legal obligation, as it turns out, and as it is affirmed in Metrolinx, requires you as an employer to conduct an investigation. And I think this case is prominent for that reason. It clarifies that sort of long-standing question. Most employers had come to the same conclusion years ago. However, some didn't, and Metrolinx answers the question. Another point that comes from this Metrolinx case is that the Ontario Court of Appeal pointed out that the arbitrator, who initially found that the firings of these 5 perpetrators could not be upheld and they would be returned to work, well, that arbitrator had based the decision on a stereotypical error, which is that if a victim doesn't have the courage to make a complaint, then the complaint must not be true. And so the courts in Ontario have roundly rejected that stereotype and have pointed out that employers have to be more diligent than that. So in conclusion, at the Ontario Court of Appeal level, the Metrolinx case stands for these principles. First of all, an employee can be disciplined for private communications, even if they take place outside the workplace, provided that they have some negative workplace impact. And my view is that in most instances, when there is chronic harassment of one employee by one or more employees outside of the workplace, that conduct does typically have a negative workplace impact. The second big point from Metrolinx is that employers are required to investigate incidents or allegations of harassment, even when formal complaints are not made. Once you become aware of the possibility of harassment or violence having occurred in the workplace, then you have to investigate. And a third point is that employers can't rely on stereotypes about how victims of harassment should behave. Finally, whether or not privacy applies to some of these social media platforms, the Court of Appeal concluded that even private encrypted messages are still subject to workplace discipline when they impact the workforce. So those are all clear and important directives from the Metrolinx case. The second one I thought I'd bring to your attention is this case from Alberta. It's not an employment case, but rather a landlord and tenant dispute in a residential context. But I thought the case has some important messaging for us in a counterintuitive way. In this case, the plaintiff was a tenant of the defendant landlord, and he made an allegation against the tenant landlord that the landlord had committed multiple acts of assault and battery, which were sexual in nature, um, um, and had arisen in sort of social contexts that involved both the tenant and the landlord. The tenant alleged that these assaults and batteries included inappropriate handshakes, spanking, and a sort of uncomfortable hug at Christmas time. It was all built on the premise that the landlord was gay and was pursuing the tenant in a romantic way. The plaintiff, the tenant, also claimed that the defendant had breached his fiduciary duty as a landlord. And this came about in a way that allowed the plaintiff to pursue financial compensation. Now, interestingly, in this case, the defendant, so the landlord, the person accused of this behavior, denied the allegations in court and counterclaimed against the plaintiff on the basis that the plaintiff's allegations were knowingly false, they had been fabricated, and that the fabricated allegations had understandably caused the defendant intentional infliction of mental distress. And so that's not an approach that is often seen in these kinds of cases, but it was taken here by the landlord. And what was found in court is that the allegations of the tenant were not credible. The court said that the handshakes were ordinary and consensual, that the alleged spanking incidents were unsubstantiated, and that the hug at Christmas time was a consensual social interaction. As a result of all of that, the court said that the plaintiff's allegations lacked credibility. The defendant's account was more credible, more believable. And on the other hand, the court found that the defendant had proved that the plaintiff's conduct for making these fabricated allegations was outrageous. And as a result of that, the defendant had in fact suffered, a mental injury. And so the defendant in this case was awarded a small amount of compensation, $10,000, but nevertheless was awarded compensation. So what I would take from this Dieterle case is that we have to be mindful in this current context that there are some people who will make complaints that aren't credible. We can see how easily that can come up as well, by the way. And so in this instance, the plaintiff and the defendant, the tenant and the landlord, were interacting socially from time to time. There were some incidents of physical contact in the form of handshakes and this hug. But what the court said is, look, some of that behavior falls within the realm of socially acceptable behavior. And so what we should keep in mind too is that when that kind of behavior is taking place within a relationship of any kind, it would be incumbent on the alleged victim to call out the behavior as unacceptable. Otherwise, it has the perspective of being consensual, and that's what took place here. Furthermore, we should be mindful of the fact that these complaints are, potentially damaging for both the alleged victim and the alleged perpetrator. And so the Dieterle case just serves as a reminder of that point. And then there's this case, the solar and professional components case this is one from British Columbia. This one's interesting because it's a case that is nuanced. The plaintiff in this case, the employee, was hired as a bookkeeper for this company that was growing, and apparently the plaintiff was accused of making an accounting error. And once that accusation was made by the employer, then the plaintiff, the employee, felt very confident that the whole workplace environment had changed for her and that she was effectively being ostracized or isolated. The evidence ended up bearing that out to some degree because the employer conceded, as a result of having to disclose a whole series of email exchanges, that the employer was extremely frustrated with this perceived error and was now seeking someone to replace the employee. During that period of seeking a replacement, the employer was, definitely giving the employee the cold shoulder, as we say. So the employee claimed that she was suffering, a hostile and reticent treatment. She claimed that her workplace was poisoned and that constituted harassment against her. She eventually claimed constructive dismissal, meaning that although the employer had not yet fired her, she might as well have been fired because the essential terms of her employment had been fundamentally altered as a consequence of this hostility and poisoned environment. So this employee quit, claimed constructive dismissal, and sought damages, which included 4 months of pay and some dental treatments that she would have been covered for under her company benefits package, but wasn't covered for as a result of the constructive dismissal claim. And the court said that, the employer, by its conduct, has made the employee's employment circumstances intolerable. Workplace harassment and the creation of a hostile work environment can form the basis of a constructive dismissal. So I thought this case was important to bring up on that point because we often think of harassment incidents as ones that are brought forward under the law by way of the occupational health and safety legislation or by way of the Human Rights Act. But employers have to remember that it's even worse than that because there is a potential claim under the employment contract for, a breach of the contract that could give rise to either a constructive dismissal claim or even an infliction of mental suffering claim of the kind that we saw in that Dieterle case. So what this case tells us is that even more surreptitious or, less active behavior on the part of a manager or a coworker, behavior of the kind that amounts to social exclusion, that can constitute harassment. It can take the form of a poisoned work environment, and it can give the employee a legal basis on which to claim constructive dismissal. I should also point out that constructive dismissal may not always require the employee to quit their job. They may be entitled to make a claim of constructive dismissal while at the same time remaining employed. That's a footnote just to illuminate the fact that an employer who is behaving this way with the hope that the employee might actually quit may not get their wish because the employer might be faced by a lawsuit and still have the employee working in the premises. there's a bit of a complication to that, but it's at least theoretically achievable. In this decision as well, the court said that the plaintiff, Ms. Solar, had described in her testimony a work environment that went from being collegial to one where she felt ostracized and marginalized. And I thought this was an important quote because it reminds us that when an employment relationship starts to break down, one thing that is sometimes intuitive for some employers is to avoid the direct confrontation of a dismissal or a disciplinary action, and instead to take a more passive but very corrosive approach, like ignoring the employee or leaving them out of company activities. And so, interestingly, in this case, the employment relationship deteriorated. It went from being a positive environment and an employment relationship that was satisfactory to all, and with really one mistake, the employee found herself in this hostile, poison work environment. So employers should set the tone in the workplace and recognize that if you have an employee who is working for your company or your organization, even if that person is perceived as having made some mistakes or their value is, less than was hoped for, the question really is, how do you deal with that employment relationship contractually, as opposed to taking, a less mature approach and trying to, freeze the person out. That shouldn't take place, and that's what this case stands for. So employers should use this case as a reminder that it's the employer who has a duty to maintain a healthy work environment, even if you have some issues with your employees. This employee was successful in her claim for constructive dismissal. She was not awarded as much as she asked for, but she did receive 3 months in pay. And then the last case I'll tell you about, the fourth one, is one that just recently came out. It's in the construction environment. It's a more typical harassment case, but it's a unionized case, so it went to arbitration. And this is a case in which there was a finding that ongoing sexual harassment had occurred to the point where there was a poison work environment, and that led to the termination of the employee/grievor. The griever was awarded compensation for loss of dignity, feelings, and self-respect. And that, that's not always the case in the unionized environment. And so I thought this case was interesting. It's a case, again, involving a construction environment. The grievor or the victim was a person who was reporting to this one particular lead hand or supervisor. And the supervisor started to welcome this guy to work by saying, excuse my language, but good morning, bitch. And he was saying that, on a frequent basis, a regular basis, for a relatively long period of time. The victim grievor, resisted that behavior, but didn't really want to bring it forward. This, I think, is a great reminder that in some workplaces, particularly, it's especially hard for victims to bring forward these kinds of allegations. And I think all of us have to be mindful of that. So here, the arbitrator accepted the griever's explanation as to why he had remained silent in respect to the lead hand or supervisor's taunts. The victim was afraid to lose his job, and, spoiler alert, he was, well justified in being afraid of losing his job, because eventually the supervisor caused the guy to be fired. And he was also intimidated by the supervisor's aggressive and angry behavior. So it was found that the supervisor had made up some reasons to eventually fire the victim. And he made up allegations that the victim, wasn't really productive at work and wasn't, efficient in his job. And so he fired the guy in a very sort of callous way. And so that resulted in the grievor bringing the issue forward to his union representative. And so it was determined that the employer was liable under the Ontario Human Rights Code because of that legislation's attraction of liability for a poison work environment. And so there you have it on that front. Again, I think the message for all of us is that victims of this kind of behavior may not feel comfortable bringing forward the allegation. And so it may be up to a coworker or management itself to advance the complaint and to make sure it's dealt with in the appropriate fashion. Some conclusions just to touch on. Harassment cases aren't becoming simpler. I would say that they are becoming more and more complicated. They do attract the potential intervention of a number of legislative provisions. Here in New Brunswick, we have a case that has attracted claims under the Human Rights Act, the Occupational Health and Safety Act, the Employment Standards Act, Public Service Labor Relations Act, and the common law. So one case can certainly trigger complaints under a variety of legislative provisions, and that makes things complicated. The second thing is that the breadth of alleged workplace harassment has been affirmed. It's not a narrow, subject matter. It's broad in nature. The Metrolinx case tells us that workplace harassment can take place outside of work, off work hours, and using an otherwise encrypted and private means of communication. So let's not wrongly assume that workplace harassment is limited to work hours and behavior inside the workplace. It's broader than that. The third bullet here is just a confirmation that no official complaint is required to be made. That puts an onus on employers, such that when employers become aware of misconduct, they have to treat it as an incident and have it investigated. Even passive behavior like ostracization can constitute harassment and can create a poison work environment. We've all suspected that, of course, and known that to be true. But once again, the Solar case confirms that. Then, with respect to harassment cases, I would say that not only are they becoming more legally complex in many instances, but also they are attracting higher and higher damages. So it's important for employers and individuals as well to be cognizant of this, because while we've talked mostly about employer liability today, even individual harassers could be found liable in some circumstances. Finally, just a gentle reminder here that there are some false allegations of harassment made. And so the Dieterle case, tells us once again that we have to be mindful of that possibility. We have to be, judicious in terms of the way that we approach investigations, because you know, an alleged perpetrator could actually be innocent. And if that's the case, then anyone who fabricates allegations of harassment could be personally liable, as was the case in the landlord and tenant matter. So those are some highlights, I would say, of the last year in harassment law. There are lots more cases that have been decided across the country. These four give us some insights that could be useful. Once again, I'll say that we should recognize that, harassment takes a number of different forms, and often, but not always, incorporates other issues like illegal human rights prohibited discrimination. And on that discrimination front, I'll point again to the Margaret Ann Blaney case here in New Brunswick for a few reasons. First, the Blaney case talks about illegal political beliefs discrimination. And I've challenged myself, and I'll challenge all of you with this question. Have we personally discriminated against people on the basis of their political beliefs? For example, have we found ourselves in circumstances where we've spoken, negatively, or we've defamed even people who hold different political beliefs than our own? And if so, do we accept the notion that by doing that, we are likely violating at least the spirit of human rights legislation, if not, the precise protections of the act? That's something I've been thinking about. I'd be interested in your thoughts too. And if you have any questions, please let me know. I'd be happy to try to answer them. Thank you.
Amazing. Thank you, Kelly, for that high level, but also very in-depth and very concrete tour of some of the developments around harassment and manager obligations, all of that kind of stuff. This is such a quickly advancing area of law. In some cases, we see things that I think, the Metrolinx principle was almost considered settled law when I was learning workplace law quite a while ago. But we're sort of firming up and committing to some areas and seeing new complications and new considerations for managers to be aware of in others. We did have one question so far in the chat. Anyone else, please feel free to submit questions for Kelly. We have some time to talk through them. The question was, what is the significance of intention behind complaints or cases? Specifically fraudulent complaints, or if there was not malicious intent behind a comment. I think this is in reference to the tenancy case that you were discussing, but can you say a little bit about how administrative bodies or courts treat the question of what do we do with and when do we care about the intent of the person who's bringing a complaint forward?
Yeah, sure. No, thanks, Michelle, and thanks for that question. I think what's settled, in my view, is that, and Michelle, you and Kerem had discussed this in the previous session as well. Intention with regard to discriminatory comments and intention with respect to harassment behaviors is not a significant factor or a factor. And so you don't have to intend to hurt someone. Simply perpetrating the act of harassment or discrimination will attract legal liability. So I think that, however, shifts slightly in the context of false allegations. So what I think is interesting about that landlord and tenant case is that the court didn't find that all of the allegations were completely untrue. Instead, you might recall that the handshakes and the Christmas hug were found to have occurred, but were found to have occurred in the context of a, social acceptance. And so what I thought was interesting about that case is that nevertheless, the court found that the tenant had fabricated the allegations. And so it wasn't a case that the fabrication lay in, the allegation that these incidents occurred, but rather the characterization of those allegations as harassment. That's where I think people have to be careful, because I think that if a certain behavior takes place, then reporting it in a workplace environment is a very safe thing to do. When you start to label it, though, when you start to characterize it as, let's say, harassment or violence, when you make the comment that, this person, this alleged perpetrator has, I don't know, reached out and touched my shoulder in a sexual way, that's when I think there is more risk, because at that point you're making a value statement about what's taken place. And the safest thing to do would be to make the allegation that the behavior occurred. That allows the investigator to determine whether the behavior is, harassment, or whether it constitutes some other kind of misconduct. That's probably the safest way for someone to report that kind of behavior.
Thank you. That makes sense. It's also interesting that that case in some ways almost feels like it's playing into some of the discriminatory stereotyping about gay men, right? Like there's still an interesting thread being picked up in that case about the fear of sexual advancement from gay men and all of that.
Yeah.
Which of course would be problematic in a landlord context, but there's all these different threads and different layers of power in that interaction that make this really thorny, complex ball. We had one more question coming through here. Out of curiosity, how are damage awards usually calculated? I know that's broad and varies a lot from process to process, but do you want to say something about that?
Yeah, sure. And thanks for that question. So first, what has to be considered is, what in law we call the pecuniary damages, which are the calculable damages. So for example, in the Francis case that Kerman mentioned, Mr. Francis was a corrections officer in British Columbia. He had suffered that racism that you all heard about. And as a consequence of that behavior, he went out on sick leave, which you can appreciate. While he's out on sick leave, financial losses start to accrue. And, often that's because a person's disability insurance coverage might be 65% of their salary. There are other losses that they might incur, like overtime pay that they haven't been able to earn and the like. So those damages are usually calculable, and you can take your calculator to figure those out. In the human rights context and in a few other legal contexts, those damages could, in certain circumstances, carry out from the date of an employee's disability, or from the date of the impact of the harassment, all the way to reasonable retirement age. And that's how you start to see these big numbers. So that's one piece of a damages calculation. A second piece is what we call non-pecuniary damages. And those are the general damages that typically relate to the affront to your dignity in the case of a human rights matter, or the psychological damage that you've suffered, the injury that you've incurred as a consequence of the misconduct. It's much more difficult, in my mind at least, to really sort of understand where the courts come from on those kinds of damages, but without getting too deeply into the weeds, there's a trilogy of cases from the Supreme Court of Canada that gives guidance on how to provide general damages to a person who's been injured, either physically or psychologically. The trier, either the board or the court, is going to consider the severity of the damage that the person suffers. And then there's the opportunity for what we call aggravated and punitive damages. And those are extra damages that can be given on an exemplary basis. The first of which, aggravated damages, is intended to more adequately compensate the victim. Punitive damages are awarded only in rare cases for the purpose of further penalizing the defendant. And so what we've seen in New Brunswick, by the way, in the last couple of years, is an escalation of those non-pecuniary damages, general damages, aggravated damages, and in at least one case, punitive damages. What that tells us is you're probably going to see more and more cases that go into the big numbers. And you can just look in the news and see some of those in New Brunswick, and you'll see big numbers.
Yeah, absolutely. We have a comment that came through that just said, "Thank you so much, Kelly." This person found the session really informative. If anyone else has questions, feel free to submit them. One of the things that jumped out to me from some of the cases that you were talking about in this is some of the fuzzy boundaries around what behavior is sort of justiciable under a workplace law framework, right? You talked about, encrypted chat systems and all of that. Is that eligible to employer scrutiny? One of the things that has been, we receive questions from the public all the time. One thing that's has been coming up periodically for us in questions over the last couple of years are questions about employer scrutiny of social media posts, texts being sent from employer given phones that are ultimately personal in nature, but are using employer equipment, searches of cars in parking lots and that sort of stuff. Is there anything you can say generally about that sort of like intersection between what we think of as private spaces or private communications and how they become workplace spaces sometimes?
Yeah, great question. These are the issues that are still, in my view, being sorted in the courts and at arbitrations. But there are a few things I think that we can take away. First, that what will be looked at is your expectation or reasonable expectation of privacy. So one of the things employees should consider is that if you've been assigned a company work phone and you know that phone belongs to the company, typically it will have attached to it a company email address, and probably that you're going to have to give that phone back. You might also have signed a policy that the company has put in place to say that the company owns the information on the phone. If all of that were true, then your expectation of privacy with respect to the content of the phone is pretty low. What that means is the employer will have a pretty good argument that it can access the contents of your phone. That same thing could be true with your laptop, if it's a company laptop. However, once you get into, privately owned gear, your own personal phone, your own personal laptop, then your privacy expectation increases, and the courts, then start to take even greater protections with the contents of that equipment. So So what I would say is first think about what's reasonable. Should you actually think that you have any sort of privacy with respect to the contents of your company-owned phone or laptop? The answer is you should probably have a low expectation on all of that. What if you're working in a workplace where the employer decides to install surveillance cameras? That can be problematic, and there can be legal action taken in some circumstances with respect to employer surveillance of that kind, even if it's out in the open. For example, if you work at a reception desk and your employer decides to install a surveillance camera that points directly at you all day, that could be a violation of your privacy. But if it's a camera that is trained on the front door and doesn't cross your workstation, then it's probably all right. These are becoming more and more difficult issues, and difficult when you get into questions of inappropriate materials being stored on company equipment. So what we see, not all the time, but surprisingly often, we'll see employees taking pictures of themselves naked and texting them to coworkers. In my view, the employer will have a pretty strong argument that you don't have any privacy right over that, especially if you're using the company equipment. And then when you get into even more serious issues like storage of illegal pornography and that sort of stuff, then your privacy rights are really low.
Right. Okay, we have two more questions for you. I think we have time, and feel free to keep sending them in. The first question is there any alternative recourse that you've seen other than, countersuit for reputational damage suffered by an employee or employer who's found to have been falsely accused with malicious intent? For example, a teacher who's placed on suspension for sexual harassment complaint pending investigation, and then it's found to be a maliciously lodged complaint.
Yeah, I think there's sort of a legal issue here and a practical issue. That's my own take on this. I think if there is a complaint filed against an individual and it's found to have been maliciously filed, then in my view, from a legal perspective, there are a couple of possible avenues. One would be a defamation of character lawsuit. And there was, and I'm sorry, I'm not going to be able to cite that one off the top of my head, but there was a recent one like that in a different province. And so I think you can contemplate legal action for defamation of character in that situation. Similarly, that tort of intentional infliction of mental suffering that we saw in the tenant and landlord case, that would be a viable claim to make. In some limited circumstances, I also believe that there's, a potential, at least, for reporting the matter to the police. That requires a few different steps, or at least factual considerations. But those are the key opportunities to try to seek, a resolution of a fabricated or maliciously made complaint from a legal perspective. I think from a practical perspective, what often happens, but please correct me if you disagree, that I think oftentimes the person who has been accused has to weigh out, and this is really unfortunate, has to weigh out, what are the benefits of reliving all of the harm caused by the malicious allegations, especially if the person making the allegations doesn't have any assets. that, that's a pragmatic consideration for many victims of malicious allegations. You might go to court and you might go through a very lengthy, arduous process. The Natasha Poirier case is slightly different, but the same on that basis. And at the end, you might have the court award you compensation, but you'll never get it because the person making the allegations doesn't have any money. So that's the problem.
Right. Right. And there's also the problem, I assume, of dragging out the presence of that issue in your life, dragging that, if you're a public figure, dragging that out in public conversation. It's a lengthening of that whole experience as well too.
Definitely.
One more question in here. This person says, I wasn't previously aware that constructive dismissal could be valid without having been fired. I always thought it was a reduction in salary without cause. What are some further examples? I think that's asking for what other types of things have been found to constitute constructive dismissal.
Yeah, sure. Great question. I find that, first, I'll say this, I find that many people speak about constructive dismissal because they've heard it as a concept, and it's a difficult concept to get your mind around. One of the leading cases in the country comes from the province of New Brunswick. In fact, in the labor and employment world, New Brunswick punches way above its weight class for delivering high-powered labor and employment decisions. The case that really sets the pace on constructive dismissal is the case of Potter against the New Brunswick Legal Aid Services Commission. And that was a Supreme Court of Canada decision made a few years ago. What it talks about is the idea that in constructive dismissal, there has to be, a fundamental shift in the nature of the employment. And so that fundamental shift is often thought of as like a change in pay. That's the most common and easiest, perhaps, example to for us to get our minds around. So if you're being paid $50,000 a year and your boss drops your pay to $30,000 a year, then that almost definitely constitutes a constructive dismissal, and it would allow you to claim for reasonable notice. That's a case, by the way, too, where I think a pretty good argument could be made that you as the employee ought to stay employed at $30,000 a year and sue the employer for the difference between 30 and 50 over a period of reasonable notice. But the courts have also said that this fundamental shift can take a variety of forms, and it doesn't have to be monetary. It doesn't have to be in the form of a demotion, like, from vice president to supervisor. It can be nuanced, as we saw in the solar case, where somebody's going to, have to endure harassment at work, or somebody is being, shunned at work. The reason why that often constitutes a constructive dismissal is because employers owe a duty to keep their employees mentally safe. Hence this big effort by Michelle and her team. And beyond that, think about this. If you were trying to prove a constructive dismissal case based on, let's say, harassment or poison work environment, you could probably find some basis for your complaint on your employer's own website, because most employers will post all sorts of, motherhood and apple pie statements about how, they care about their employees and they're being very careful to protect their employees and create a good work environment. And I'm sure they mean that. I'm sure they want that to be true. But that evidence would be useful in a constructive dismissal case that's based on, say, a poison work environment allegation. So that can also constitute a fundamental change. Here's one for you that people don't really, they're not very aware of, but there was a case involving T-Bay Tel, which is like Thunder Bay Telephone Company. And the female plaintiff's name escapes me at the moment. It might be Castro. In any event, if anyone needs that, send me an email. I'll get it for you because it's on the tip of my tongue. But what happened is, get this: the female employee was working for T-Baytel. She found out through the grapevine that the company was planning to hire a male employee who had sexually harassed this woman in a previous company years before. So the female employee went to the company and said, look, this isn't going to work for me. If you hire that guy, just know that he sexually harassed me in a previous work environment. I'm not going to be able to tolerate working here. And the company said, well, sorry, we're going to proceed with hiring the guy. And they did. She then quit and claimed constructive dismissal on the basis that they had failed to, observe her safety. That was found to be constructive dismissal, and she was successful in her lawsuit. So hopefully that example gives you a bit of an idea as to how constructive dismissal has taken a pretty broad, definition.
Yeah. Yeah. Awesome. Thank you so much for that, Kelly. That was amazing. I hope everyone found it as interesting as I do as a law nerd. I really, really always appreciate the way that you are able to take legal principles, explain them clearly, connect them to why it matters for all of our life at work and as managers or as staff or any of that, and what it means for sort of the direction that we're moving our whole of law in. So thank you for laying all of that out for us and for being here.
Thank you.
Of course. And that brings us to the end of Respectful Workplace Week 2025, at least the forum. We still have a workshop on tomorrow. But before we close, I'd just like to say thank you to a few people. First of all, thank you to everyone who contributed to planning and organizing this event. I'm going to name a few of them, not all. Amber Chisholm, Shanice Norad, Marian Hernandez, Jaylene DeAdder, Alexis Coleman, Nicole Smith, Trish Noble, Heather McTiernan, Genevieve Pilon, and many, many others. Thank you also to everyone who is involved in supporting Respectful Workplace Week behind the scenes, including Denis Gagnon, Rebecca Francis, Martine Stewart, Lizzie Manuel, Myrna Belia Tracy, and to the Minister for Women's Equality, Lynn Chantal Boudreau, for declaring Respectful Workplace Week for the province of New Brunswick. We are so grateful for your ongoing support. Respectful Workplace Week has always been a coalition project. It was planned and run by a committee for a lot of years that included members of government and academia and the nonprofit sector. And as Plius has stepped up to be sort of the main host organizer, we are depending on all of our networks and all of you as much as we ever have. And we're so grateful that you've continued to care about this event and to help us pull it together and to show up for it. And to everyone who's been involved in running the forum over the last 2 days, big thank you to Nicole Smith for her excellent hosting yesterday, to Matt Smith for running Zoom and providing tech support over both of these days, and to all of our speakers who were incredible this year, Julie Whiteneck, Christiana Myers, Angela Acott Smith, Melanie Pauley, Matt Kalichuk, Ali Heighton Lamb, Soph Mellitz, Angela Black, and today's two wonderful speakers, Khurram Khurshid and Kelly Van Buskirk. We are so grateful for all of your time, all of the knowledge that you have shared, and all of the work that you do year-round to help us all have better, healthier workplaces. Thank you also to our translators, led by Chrissy Michaud. We love working with you every year, and we appreciate all that you do. And finally, thank you to all of you who have joined us over the last 2 days. It's amazing that we have such a strong audience of people who care about our workplaces and engage with this topic year after year. I hope you learned something from the 2025 forum, something that will be useful to you in your work, something that made you think, something that you'll carry into your personal practice. And I really hope we'll see you next year. Before you leave, just a reminder that when you close this window, you will be prompted to fill out a very short feedback survey. It should take less than 2 minutes, and your comments and suggestions are so helpful to us. We read through all of them. We take them really seriously. So please take a moment to tell us what you thought. If you have any questions or want to follow up on any part of this program, you can email us at info@legalinfonb.ca. And we will send you materials or put you in touch with the right people, try to find you answers if you have outstanding questions, whatever you need. If you need to find that contact info again, you can Google PLIAS Public Legal Education Information Service of New Brunswick, or find our website at legalinfonb.ca. All of the videos from this forum will be available online shortly through PLIAS's website. And that's it. Once more, thank you to everyone who was involved in producing this event, and we will see you all in 2026.